This episode of The Dig is brought to you by our listeners who support us at patreon.com and by Verso Books, which has loads of great left-wing titles, perfect for Dig listeners like you. One that you might like is Who Killed Berta Cáceres? Dams, Death Squads, and an Indigenous Defender's Battle for the Planet by Nina Lacani. The first time Honduran indigenous leader Berta Cáceres met the journalist Nina Lacani, Cáceres said, "The army has an assassination list with my name at the top. I want to live, but in this country, there is total impunity. When they want to kill me, they will do it." In 2015, Cáceres won the Goldman Prize, the world's most prestigious environmental award, for leading a campaign to stop construction of an internationally funded hydroelectric dam on a river sacred to her Lenca people. Less than 1 year later, she was dead. Many questions about who ordered and paid for the killing remain unanswered. Drawing on more than 100 interviews, confidential legal filings, and corporate documents unearthed after years of reporting in Honduras, Lacani paints an intimate portrait of an extraordinary woman in a state beholden to corporate powers, organized crime, and the United States. Who Killed Berta Cáceres? Dams, Death Squads, and an Indigenous Defender's Battle for the Planet by Nina Lacani. Out now from Verso Books. Welcome to The Dig, a podcast from Jacobin Magazine. My name is Daniel Denver, and I'm broadcasting from Providence, Rhode Island. The Republican Party uses minority rule to impose a right-wing agenda upon a majority that opposes everything that they stand for. Neither Bush nor Trump would have been president if we lived under a state that had the most basic features of a democracy. Mitch McConnell would not be Senate Majority Leader. John Roberts, Samuel Alito, Brett Kavanaugh, and Neil Gorsuch would not be on the Supreme Court. Indeed, you would have no idea who those people were. And yet, Democrats join Republicans in pledging fealty to an exceptionally American system that has, since it was founded by our hallowed Constitution, systematically excluded the people it exploits and expropriates the most. A system that today uses the Electoral College, the Senate, state and federal district gerrymandering, and yes, the Supreme Court to consecrate minority rule, all as millions of working-class immigrants are denied the citizenship rights they are due, and millions of poor, working-class, Black and Latino Americans are caught within a massive carceral state whose coercive powers extend far beyond the prison walls. Today's episode is about the Supreme Court and RBG's passing and court veneration in particular, and about the relationship between law and politics in the United States in general. It's an interview with legal scholars Aziz Rana and Amna Akbar and Movement for Black Lives lawyer Marbre Stahly-Butts. Most perversely and revealingly, the liberal politics of court veneration exposed by the mourning of Ruth Bader Ginsburg served to sacralize the very council of life-tenured elders that Republicans are unsentimentally and methodically taking over, even as Ginsburg refused to step down under Obama, refusing to recognize what the right very clearly understands: that politics inescapably pervade the law. And yet, maybe there's something else here too. The brazenness of the right-wing attacks does seem to have finally, began to trouble the court's legitimacy as more liberals begin to raise the intriguing if insufficient call to pack the courts. How should the left think about all of this? What about more radical proposals to curb the court's power rather than merely tinkering with its partisan complexion? How is it that amid a year of mass struggle against the carceral state and police violence, that the judiciary and Supreme Court's role in facilitating the rise of mass incarceration goes unmentioned in mainstream debates over Amy Coney Barrett's nomination? How is it that liberal norms and institutions fanatics like Yasha Mounk credit the Warren Court for the entirety of the civil rights revolution, writing the lead role played by mass struggle and congressional legislation out of history? How did this brief progressive exception help cement this false notion that the Supreme Court is a progressive bulwark rather than the reactionary institution that it has been for most of U.S. history? How did that, in turn, affirm liberal faith in anti-democratic institutions and hostility toward the people and populism? Why was the Warren Court's defendant rights revolution followed by the rise of the carceral state? Why do we exclusively see the court as a venue for the resolution of so-called social issues, even as the court does nothing to stop mass incarceration and empowers corporations against workers and consumers? These are a few of the questions that we take a first stab at answering in what I promise is a really fascinating conversation. But before we get started, as you likely know, this podcast is a listener-supported operation, and the place that you, our listeners, support us is at patreon.com/thedig. When I started this podcast nearly 4 years ago, I had no clue what I was doing. And I certainly did not anticipate that this would become my full-time job, or that it even could. All I knew was that on the one hand, there were a lot of smart left-wing intellectuals, and on the other hand, a newly resurgent socialist left. And I knew that I wanted to do extremely long, in-depth interviews that made the most sophisticated left-wing analysis available to all of you so that you could better understand the world as you sought to change it. Now, thanks to your support, this is what I do for a living, even as I do a part-time job worth of volunteer organizing on the side. And it's not just my job, but I'm able to pay my producer and people who help with the book club and sending books out in the mail and all of that. And that's all possible because you, our listeners, support us at patreon.com/thedig. So if you have not done so yet, please take a moment to make a contribution. Those of you who can afford to contribute, doing so is what allows us to make all of our episodes available for free so that everyone can listen regardless of their economic means. That's patreon.com/thedig. And then one other thing that I should be plugging a lot more, which is the Dig Book Club. Do you like these interviews? Do you want to read the books, or at least some of the books, that these interviews are about? Do you want to discuss those books with fellow Dig listeners and also with the authors who wrote the books? Well, then you should join a Dig book club. We have a bunch of listener-led Dig book clubs meeting virtually all over the country. We choose one book a month. You discuss it with your club. Then we have a big Zoom event where all of you post questions about the book to the author. This month's book is Paul Renfro's Stranger Danger, Family Values, Childhood, in the American Carceral State, which I recently did an episode on. To sign up for a book club, visit thedigradio.com/dig-book-club. That's thedigradio.com, dig-book-club. Okay, thank you. And here is Aziz Rana, Amna Akbar, and Marbre Stahly-Butts. Aziz Rana is a law professor at Cornell and the author of the book, The Two Faces of American Freedom, and a frequent presence here on this podcast. Amna Akbar is a law professor at The Ohio State University who writes about today's left social movements, their experiments, and demands. Marbre Stahly-Butts is a movement lawyer and executive director of Law for Black Lives. She is a member of the Movement for Black Lives and one of the architects behind the Vision for Black Lives policy platform and Black Mama's Bailouts. Aziz Rana, Amna Akbar, and Marbre Stahly-Butts. Welcome to The Dig.
It's great to be here.
Great to be here.
Thank you so much.
Sam Moyne recently told Jacobin, quote, "In the end, I think we'll have to read Ginsburg's legacy through the bet she made on her own longevity while leaving others to deal with the consequences." I'll start by stipulating that I think Moyne is right, but I want to ask you if you agree. Does Ginsburg's refusal to exit when Obama was president and had a Democratic Senate and her commitment to believing that her tenure on the court was somehow elevated above politics, and the fact that myopia has now given Trump another open seat to fill with a right-winger, does that all reveal that liberals have become the victims of their own veneration of the Supreme Court in general and Justice Ginsburg in particular? And if so, what should we make of that?
So I guess I'll jump in first. So what Sam Moyne's talking about is the fact that when Obama won re-election in 2012, Democrats actually had control of the Senate. And because they had control of both the Senate and the presidency, it's very possible that you could have had Ginsburg step down and then that seat be replaced with a Democratic appointment, essentially. And I think it's true that a particular kind of political call not to do that at that moment will be part, ultimately, of Ginsburg's legacy. I don't think it's the sum total of her legacy, but it's certainly part of the story. And I also think it speaks to something really specific, basically to an earlier era in American politics that even lasted into the mid-2010s, which is this idea that there could be bipartisanship and bonhomie across the divide, that somebody like Ginsburg could be friends with Scalia, that you could presume that the Democrats and the Republicans would behave more or less the same, that they largely had the same Cold War vision of American identity. And so in a way, perhaps less a kind of paean to the Supreme Court in particular, it was an embodiment of a shared vision of the U.S. that was quickly sort of moving out of step with reality. But the one thing that I'd add is just a last point, which is I'm a little wary of personalizing this as about Ginsburg. I think in general, it's really tough for people that have power, that are exercising extreme power, to give up that power. She served on the Supreme Court for 27 years. You know, John Paul Stevens served for 35 years. Scalia died serving in his 30th year. Clarence Thomas has been on the court for 29 years. I think, my hope is that the legacy will be we should have no institutions in which individuals are able to accumulate this kind of sustained lifetime power. So the lesson should be that we have to, basically fundamentally transform the nature of the court rather than focusing specifically on the person.
Marbre?
Yeah, so I would agree with what has been said. I think I would say, though, that I think the vision of kind of bipartisanship, or this idea that somehow there were things above politics, has always been a fallacy. So I don't think that ended with this kind of moment of polarization. There's a James Baldwin quote that says, "We can disagree and still love each other as long as the disagreement isn't rooted in my oppression or denial of my humanity or right to exist." And so I think the reality is that very often, because the kind of people who serve on these courts are not directly impacted, that it can all be kind of very civil and there can be a lot of decorum. But the reality is that these issues have always been deeply, deeply, deeply personal and have always been very divisive. And so I think in the legal profession, there's a general civility that happens. You have prosecutors who are besties with defense attorneys, and all of that, I think, is really disconcerting and disturbing for the folks who actually bear the brunt of these decisions. It's not civil, the things that happen as a result of these decisions. And so I think this kind of mythology of civility, this mythology of bipartisanship, it really has broken apart, and the emperor has no clothes on. But the reality is that this existed long before this moment, right? And I completely agree that kind of having the same people who are very elite, who have very little kind of direct experiences with these systems in these positions of lifelong power is incredibly problematic. And I hope that this moment calls attention to just how undemocratic and how problematic the court is. But I do think that there is like this kind of running fallacy around the civility of our politics before this moment.
Yeah, I think that's a really good point. This about the liberal RBG veneration is that it seems almost though as her close friendship with Scalia was not just tolerated, but almost celebrated as a sign of her virtue.
I think the focus on the nature of the friendship is actually one of the things that's particularly destructive, because it does play into the idea that the judges are somehow above politics, that they actually share a kind of common experience, which is that they're high officials of the state, committed to the law, engaged in a project of upholding the rule of law. And so the thing that Ginsburg and Scalia have in common is that they're both these sort of supreme figures, and they're supreme figures that participate in especially worthy forms of jurisprudential reasoning. And all of this, I think, feeds into a kind of cult that is deeply anti-democratic. And so what I would say is that if, along with raising basic questions about whether or not we should have lifetime judges enjoying this kind of power, if we can also have a conversation about the cult itself, I think that would be really valuable. If, let's say, in 10, 15, 20 years, we honestly didn't know who was on the Supreme Court. Like, we couldn't, nobody could pick out the names of the judges, the justices. That, to me, would be a sign of democratic health. And the fact that, depending on your political side, we have these obsessions with the justices, including, former clerks standing in front of the court out of like a kind of, honor to the justice. Like, that, to me, is a sign of democratic illness, essentially.
Yeah, I think things are pretty ill at the moment. Longtime SCOTUS reporter Linda Greenhouse, at the time when some people were trying to nudge RBG from the court under Obama, she wrote, quote, "I think from her perspective, she is taking a long view of history, not a case-by-case one or a term-by-term one. I think she feels that it belittles and diminishes the court to have retirement so obviously timed for political reasons. And many liberal feminists push back against calls for Ginsburg to step down. We heard it from Emily Bazelon at Slate, and of course from the famous or infamous Notorious RBG book, which put it like so, quote, "Historically, one way women have lost power is by being nudged out the door to make room for someone else. Not long before pop culture discovered RBG, liberal law professors and commentators began telling her the best thing she could do for what she cared about was to quit, so that President Barack Obama could appoint a successor. RBG, ardently devoted to her job, has mostly brushed that dirt off her shoulder. Her refusal to meekly shuffle off the stage has been another public, high-stakes act of defiance." What do you make of this liberal feminist politics that is so invested in one very elite woman in the face of such clearly catastrophic consequences for so many women?
I want to tie the prior conversation to this question because I think one of the things it points to, one of the really marked things I think about our contemporary political moment is it's clear that Republicans are and have been for decades fighting for power. And they are disciplined they know what their vision is, even if there's kind of some diversity there, they have some shared things that they're fighting for. They're very disciplined about kind of using all the different tactics and strategies at their disposal to achieve it. And on the other hand, Democrats are very committed to discourse and to some extent to questions of representation and diversity. And so going back, for example, to the prior conversation about Scalia and Ginsburg's friendship, I think one of the other reasons that that's celebrated is this idea that the law writ large, so not just the Supreme Court, but law as a place of resolving disputes, is in general, the way that it's celebrated in liberal discourse is a place where you come, you make the arguments, and the best argument will prevail, right? So there's no questions about power. It's about kind of, whoever can kind of, it's a marketplace of ideas kind of reasoning, and whoever kind of has the best argument will prevail. And so once you take power out of the question, once you take politics out of the question, then you are going to cherish and value and celebrate the fact that you have an esteemed conservative jurist, Scalia, and an esteemed liberal jurist be able to talk to one another, because they're going to be able to see past the politics and the power in order to kind of talk about, quote unquote, the real things that matter, which is, ostensibly a system that has a kind of coherence that kind of comes together, right? And that's kind of, in some sense, the liberal fantasy of our legal system in the United States. And so similarly, this liberal feminist kind of concern or hesitation about the critique of Ginsburg's refusal to step down before feels similar to me in this way, which is that I think Republicans think very strategically about appointments to the Supreme Court, how young people are, how long they're going to be on the Supreme Court, and what is the right strategy to thinking about appointments to make sure that they have a hold on the court. Whereas for Democrats, there's a bunch of other stuff in the mix, and they're not so laser focused on any kind of large power moves or effectuating any particular vision. And so the question becomes reduced to whether or not we are insulting or undermining the agency of a particular woman that got appointed to the court decades ago, as opposed to thinking of a larger strategy of how to think about the Supreme Court, say, in the question of advancing women's liberation.
Republicans would appoint a 23-year-old ideologue if they could get away with it. Marbre?
No, I think I mostly agree with what's been said. I'm holding on to this thought from both questions around the ways in which these conversations really sanitize the violence of the law that happens in the Supreme Court. And so whether it's a healthcare decision or an execution, the array of things that the Supreme Court gets to decide that enact violence on communities, I think is really profound. And all of this kind of civility, these discussions around like what become like objective conversations, like, oh, this is about, this kind of objective truth or this objective high or constitutional like veneration, I think really erase and sanitize just how violent many of these decisions are. And so I think the kind of feminist liberal critique, which is very kind of second wave feminist to me, that doesn't incorporate like a more intersectional approach, which I think is important, reflects the same kind of thing of like really sanitizing the ways in which the actual decisions, the impact of this decision is going to have on communities that are left out of any of these discussions.
Aziz?
Yeah, it reminds me a little bit, actually, of the conversations that occurred right after Obama left office about how he was using his post-presidency, giving high-profile like speeches to corporations where he's getting paid huge amounts of money, like hanging out on private islands with billionaires. And, it's a little bit apples and oranges, but, one of the criticisms of pushback was like, well, wait a second. Why nobody was making these arguments previously when we had white presidents, and now that we have an African-American president, it's inappropriate to make these arguments. And I think, in a sense, that kind of criticism faced the same sorts of problems that Amna was highlighting, which is really failing to distinguish between the person and the question of power that's being represented and reproduced. And so I think it's appropriate on the one hand to say that, well, Ginsburg has a right to make choices about how she wants to pursue her own professional career, while on the other hand saying there are potential lasting problems with the particular kind of power implications of the choices that get made.
Just the point that's been made, I think that it points out how glaringly unjust the current structure is. And so the fact that a person can make that decision and that the impact of that is what it's going to be, I think speaks to the more systemic problem of having a court the way that we have it, which I assume is your next question. But I think that it's really important just to name that of like, that to even be able to make that decision on your own, to have that autonomy, like I'm going to serve out my entire life and then leave and let there be a 6 majority that will have all these other implications. The right to do that is part of, I think, the kind of original sin of our Constitution, but also I think it's really problematic for this institution, its legitimacy.
Why is there no meaningful liberal or left counterpart to the Federalist Society? Why is it that conservatives, as everyone has mentioned so many times totally correctly, have this just cold-blooded, realpolitik approach to the courts, even with all their pretense to being committed to originalism and textualism and whatnot, whereas liberal reverence for the judiciary really seems to preclude them from taking that sort of approach? Why?
So I was going to say that I do think the story is a little bit more complicated, that there have been efforts basically since 2000 to create not left, but like liberal alternatives to the Federalist Society. And the most kind of well-known example of this is something called the American Constitution Society that has chapters across campuses at law schools in the US. And I think some of this has to do with a kind of bet that was made within the liberal legal establishment at elite schools and elsewhere, which was, demography is basically on our side. We're going to be winning elections for the long term. And if we win these elections, we basically are going to be able, over the long term, to shape who's on the court. And so the arguments that we develop as a matter of constitutional interpretation are basically going to win. And it's going to end up strengthening ACS. The ACS will be a kind of mechanism that'll get people clerkships or that will shape who's on the judiciary. And I do want to say that like that bet was very close to actually winning, in the sense that, like, imagine Gore gets elected in 2000 and Clinton gets elected in 2016. It's very possible that you could have had a center-left reshaping of the federal judiciary with institutions like the ACS stronger in terms. But basically, because those two historical events did not occur, that it really ended up undermining the institutional power of these mechanisms that existed to put sort of left-leaning people into clerkships, have young judges on the courts, et cetera. And so it's meant that today now we're left with the fact that basically those kinds of internal institutions are really weak, and the center-left has to confront really the big structural problems of the court generally.
Let me see if I can put out a view that's slightly in tension to that. I mean, I don't disagree with anything that Aziz said, but it seems to me that there's a way in which the liberal veneration of the Constitution and the centralization of the courts and litigation as a central strategy to advance liberal causes for the last several decades, in kind of conversation with the ongoing onslaught by neoliberalism of everyday people's access to meaningful work and adequate wages and not having routine contact with the police or being thrown into jail and prison, means that through the last few decades that Aziz is talking about, our formal institutions of government, whether that's courts or Congress or president, generally have kind of had a rightward drift, whereas the market and corporate power have been on the rise, and everyday people's reality is becoming more and more difficult, more and more precarious. Okay, so that's part one. The second part of that I think is important to kind of tease out and think about is that I think because a lot of the liberal strategy or the kind of center-left progressive kind of strategy around justice struggles or trying to square kind of the contradictions of the promise of the United States and the reality for most people has been to focus on the courts. One of the implications of focusing on the courts as a way to advance your cause is that you focus all of your firepower on convincing elites, right? So people often say that one of the problems with law is that it depoliticizes conflicts, and there are many ways that it does that. But one of the central ways that it does that is that it makes one of the most important forums for fights over large-scale, deep, fundamental questions in forums of in judicial forums, so in front of courts and in front of elite, powerful actors. And so as a result, you kind of forego mass political struggle. You forego engaging the public in kind of, thinking or rethinking what it is that we are fighting about or what we're about. And so I think the combination of those things, on the one hand, I see what Aziz is saying, that, maybe ACS with some, if popular vote prevailed or if Gore fought harder, we would probably be in a different situation in some sense. But I also think there are deeper dynamics at play that suggest to me that we wouldn't be in that different of a place.
Yeah, so just to clarify, I think it's Amna's point is absolutely right. So I would just distinguish between what I'm describing is basically like the centrist strategy and what an emancipatory left politics would be, which actually requires pretty fundamentally transforming the constitutional system. The point that I just make is that there's a way in which we think, the center had no strategy. They kind of had a strategy. It failed pretty miserably, in part because of some of these contingent events. But let's say Gore had won or Clinton had won, that would not actually get us toward the kind of emancipatory project that we would need, because it's not one that would be built around, making sure that we have like the right judges in office, or that we just change like the particulars of the constitutional interpretation. So I guess I just read the question to be about, why is it that the center doesn't have institutions that look like the Federalist Society? But I totally agree about the general critique of the center's approach.
And it's just to say that I think liberalism would be in crisis right now either way.
Yeah, totally.
I have amens for all of that, especially I think the last piece of that, which is that whether or not the center left had been successful in its bets, we would still be in crisis. The other reality, I think, though, is the center left was also betting on the legitimacy of a lot of different institutions that have failed us. So the court being one of them, but the idea that whether it's this census moment that we are in, whether it is the complete madness around this election that we'll continue to see, that there have been a series of bets on the legitimacy of institutions that have failed the center left that I think we should take note of. But I also think the reality is that, the 1960s in the court was an aberration, that historically the court has always been an enemy of the people, whether it is around slavery, in which it required an armed war to decry and to really push back the court's decision, whether it was around sterilization and disability justice and rights and the ability to sterilize Black and brown people with disabilities, whether it was around workers' rights during the lockdown. Over and over again, it is a rarity for the court to be on the side. And when it is on the side of the people, it is because there has been literally normally decades of people in the street, of protests, of folks operating power in that way. And so I think it really is important for us to say that the bet the center made on the court was a failing one anyway, because the reality is that the court has continued to, since its inception, and was meant to fail people who are on the side, I think, of justice and power for those who are often most oppressed and left out of these institutions. That is no accident. And there was not a good bet that would have, I think, allowed them to operate power in that way. But again, that's the project of the left, not the center left. So I think
I think Marbre is making a really important point here, which is that the Warren Court, I think, looms really large in shaping people's understanding, or maybe better put, misunderstanding of the Supreme Court as an institution, and why liberals, and to a certain extent very much leftists, I think, have also have long looked to the court to protect minorities against the tyranny of the majority. But it makes it really hard for people to understand, as Marbre just said, that this is an exception to the rule for a generally reactionary institution, and obscures the fact that it was mass democratic politics of the New Deal, civil rights, Great Society era that made the Warren Court what it was. But then on top of that, even many liberals, and I'm thinking about Yascha Mounk's book, which I read to review a few years ago, really exaggerate the Warren Court's role in civil rights and other struggles, as if it wasn't in reality very much moved forward directly by mass action and legislation that resulted from mass action. Following up on what Marbre said, Aziz and Amna, how do you see the historic role of the Warren Court then and now throughout the past half century shaping liberal politics around the Supreme Court and the judiciary in general?
Yeah, I think this is really significant. And I think it's significant in part because, today when we have conversations about the Constitution, basically these are conversations about the court and about court jurisprudence, like the cases before the court. So Constitution and court, basically Supreme Court, more or less just get combined together. And the appropriate person that you turn to, tell me about what's going on with respect to the Constitution, is a constitutional law professor. So unfortunately, that's my own professional setting, but I think it's a kind of an absurd situation where our entire conversation about the Constitution takes place through what's said on the court, and it has these privileged interlocutors who are these law professor intermediaries. And it's just really, I think, worthwhile noting that that's not remotely always been the case. So that even in legal education, constitutional law was rarely taught when legal education started in this country, and that constitutional law as a required class didn't basically emerge until the 1920s and the 1930s. Most of legal education was about private common law subjects, so things like torts, property, contracts. And where you studied, if you were going to study as a matter of higher education, like the Constitution, it was going to be in history classes or in political science classes, because it wouldn't make any sense to understand the Constitution just by focusing on what Supreme Court justices said, because the Constitution is a massive system of design. It's a legal political order that has all of these decision-making consequences. And so, reading cases by judges wasn't going to help you answer those questions. And even rights, the way that socialists and New Dealers thought about rights was as much guaranteed by mass movements through amendment and legislative action as by the courts, because the history of the courts, as Marbre said, was a really negative history of sustaining privilege in virtually every imaginable way that you can think of. And so, this is all a second half of the 20th century development, where it's in that period that the most famous law professors become constitutional law professors, that the court is able to claim this authority as the protector of rights. And there's a very specific kind of Cold War story tied to not just the Warren Court era, Brown versus Board of Education, but also to the politics around the Soviet Union that has a lot to do with this.
One interesting thing about the Warren Court is that it's a touchstone for conservatives, too. But the right learned this political lesson from the Warren Court, whereas liberals learned like an anti-political lesson. The right has since then pursued the strategy of condemning liberal activist judges as a reaction to Warren Court era reforms, all the way back to 1961 when the John Birch Society launched its Impeach Earl Warren campaign, which covered this country with billboards saying just that. And the right has amazingly constructed the figure of the liberal activist judge to mobilize a political program behind developing and securing appointments for hard right judges who, ironically but revealingly, pursue conservative activism on the court. I guess this is sort of returning to that realpolitik question of like, how did this dynamic where everyone talks about the court as this thing that's above politics, but only liberals seem to actually believe that?
I've been thinking about this recently. The idea that law is above politics, separate from politics, is central to law's legitimacy in the United States. But whereas liberals seem to buy that myth, conservatives seem to understand that it's a myth in service of the legitimacy of the system, but they don't kind of act accordingly. So, for example, one of the kind of central, kind of attributes of law, one of the things that we're supposed to celebrate about it is the idea of finality, right? So you have a legal dispute and then a court decides it, and that's kind of the final decision. And if you believe in finality, then, that's kind of the last word and that's the end of it. Whereas if you kind of understand that any particular court decision is a particular court decision in that moment, you might think about it very differently. So, for example, with Roe versus Wade, liberals, progressives, the left, women get that victory of having the right to an abortion. And then ever since then, conservatives have been fighting to have Roe versus Wade overturned because they understand that, like any other judicial decision, it's a contingent decision produced in a particular political context with particular parties before the courts, and that there are strategies and ways to kind of undo that. And I think because liberals don't see law as a terrain or form of political struggle, they have kind of foregone that in as serious, deep, or meaningful ways as conservatives. I did want to say about the Warren Court, because of course one of the things that's celebrated about the Warren Court is the criminal procedure revolution, right? That's what it's often called, the idea that the court stepped in on behalf of quote unquote criminal defendants to make the criminal justice system, so-called, more just and more fair. And of course, one of the things that we've seen is that since the Warren Court rights revolution is precisely when you see the explosion in prison and jail infrastructure around the country, the explosion of spending on police, and really the rise of mass incarceration, mass criminalization, and policing. And so as much as I think the questions and strategies around rights are very complicated, I think one of the really difficult takeaways from the kind of material footprint that we can see and that we experience now from the Warren Court's jurisprudence on criminal procedure is that actually when rights attach to state violence, that it legitimates exercise of that state violence for a lot of the public, and it authorizes its exponential expansion.
Yeah, Marbre, I wanted to ask you about this because one of the most glaring absences in so much of the debate over the court is RBG passed amid a year with the largest mass street protest movement in U.S. history, specifically against police violence in the carceral state. And even though we have an Eighth Amendment that ostensibly bars cruel and unusual punishment, the judiciary has done next to nothing to stop the rise of mass incarceration over the past half century. There was that one case around California decarceration. That's the only thing that comes to mind for me as something substantial done. But otherwise, they've presided over the rise of mass incarceration. Ginsburg very much included. What does it reveal about the courts that their involvements in questions of criminal justice, really the most important way that everyday people confront the judiciary, the criminal justice system, that those questions have been all but limited to individual defendant due process rights while failing to do anything to stop this country's unprecedented system of mass human caging.
I mean, it's not just that. It's also that the court has over and over again chosen to maintain and to protect violent actors inside of it, right? So whether that's prosecutors around misconduct, whether that's the invention of qualifying immunity, like over and over again, liberal and conservative justices have both decided and engaged in really a project of building up the legitimacy of caging people at alarming rates, right? And what I think it tells us is the failure of these institutions, even when they are operated and captained by folks who we consider to be liberal. And I think that disconnect is around accountability, that the court, both the court kind of that you go to in your county or your city or the Supreme Court really lacks all accountability to the folks who it's supposed to be serving and to whom it says that it owes justice. But I think the reality is that we've seen, and whether it's in Ginsburg's judgments, or quite frankly, the Warren Court, which really chose procedural over substance. And over again decided that if we awarded people a process, that we didn't have to give them justice. And I think that the attachment, and I think Amna said this, but the attachment and the really like the devotion to a constitution that has, I think in many ways, outlived its utility by these judges is, I think, part of the problem that we're seeing, that really we're in a moment where what's being called for is a complete evacuation of what came before. And that these institutions, whether it's the Supreme Court or the Constitution, were both built to do what they're doing, which is to keep and protect elite folks. I think Aziz said this of kind of like the court is maintaining history by any logic possible, and other institutions are maintaining status quo in similar ways. And so I think it's really important that we not mistake if we are on a project of actual, and for me, it's a project of abolition to get rid of the prison industrial complex. The court will not be our friend in that, even if there are quote unquote liberal judges on it. And we've seen over and over again decisions that really have cemented the relationship between police, prosecutors, and judges in opposition to the millions of folks who are being caged.
Aziz, is there a more glaring indictment of liberal law without politics than mass incarceration?
No, I think that's absolutely right. And part of what I would say here is that it really highlights, I think, one of the constitutive flaws of the liberal imagination that ties back to, the initial question about how, in a sense, liberals were defeated politically in the story around the court, is the profound anti-populism of liberal politics. So from the mid-20th century all the way to Clinton, and Obama. And by this, I mean that there is a story that became really central to liberal politics that where does mass violence come from? It's not, the violence that's perpetrated by the state through things like mass incarceration or the treatment of migrant communities, or like during the Red Scare, the massive state crackdowns on radical dissidents, especially African Americans and those in the labor movement. That mass violence comes from below. It's sort of like there's a demonization of the people, and they're the primary folks that are threats to rights. And if they're the primary folks that are threats to rights, then the best way to ensure the protection of rights is to have decision-making in incredibly insulated arenas like the court that are elite, that are culturally controlled by elite institutions that circulate the same set of people. And, I think this is part of we were talking about like the bet that the center left made. This is part of the reason why they focused on, attempting to make changes at the margins when it comes to constitutional jurisprudence, because the other option, the left option, is mass democratic politics that's properly about altering the terms of the existing state. And in a sense, if you really are fearful of the people writ large, and you have this story about like, well, rights are best protected by these insulated actors, then you take the Warren Court era, even all of its problems, as, well, that's an indicator of the success of the story, and then you kind of hold firm to it. And anytime you see any critiques of the court from the left or the right, that's like a threat to the very possibility of rights talk. So I think that the kind of embedded anti-populism sort of explains why, liberals basically fail to see state violence and see violence as something that's only, a product of popular energy.
I mean, meanwhile, the libertarian hold on conservative and Republican politics is on the rise, right? And so the violence of and extractive quality of the market is erased from legal discourse and, politics more broadly. Those puzzle pieces fit together in an interesting way.
Yeah, that's a really important point. Jed Purdy's called it the boss's constitution, but we always have Supreme Court debates focused on so-called social issues. I find the whole concept and category of social issues absurd, but we think about abortion, we think about gay rights, we do not think about economic politics, even as with arbitration law, right-wing attacks on the redistributive state, which almost succeeded with overturning Obamacare, came that close and may very well happen now. The successful move to undercut public employees' collective bargaining rights. Why, Amna, to follow up on what you just said there, why is it that we don't see so clearly the economic politics of the court?
I mean, I think Jed and others have written about this in terms of the rise in the 20th century. Aziz might be able to recount this better than I can, but the rise in the 20th century of what they call the 20th century synthesis, central to which is the rise of law and economics and the domination of this idea that economics and politics is separate, and that the proper kind of questions, as you were gesturing at, for the law and for legal inquiry is about questions of state violence, and that questions of power and distribution become irrelevant to legal and constitutional debates.
Marbre, Aziz?
Another thing that I guess I would add here too is that there's a real way in which the debates about the court have been set by the presumption that there was a mid 20th century settlement. There's like a liberal settlement that basically everybody more or less agrees to. And this is a settlement that has to do with the basic constitutionality of the New Deal order. And that's something that's like kind of taken for granted. And, I think a lot of what we've seen over the last few decades is a sustained kind of, right-wing, basically uprooting of that settlement. But there's a way in which there remains a kind of presumption that we still more or less live in that New Deal order, and the things that we primarily fight about are questions of membership and inclusion. And so it essentially occludes the extent to which there's been a really fundamental transformation of the nature of the state over the last 30, 40 years that are directly connected to questions of membership, that these two things can't actually be separated. And, I think there's a clear way in which liberals have participated in this, because the simple truth is that liberals have largely taken on board a basic assumption about the legitimacy of market capitalism. They don't see the question about about social democracy and the welfare state as like the central battleground of political struggle. And, many of the cases that we can think of as kind of pro-business cases creating the new Lochner are cases in which you have some centrist support on the court for. These are not necessarily 5-4 decisions. So all of these are, I think, puzzle pieces that end up fitting together.
Yeah, I would amen all of that. I think that it's a really important, when we talk about kind of sites of violence, the economic violence is important. And this reality that the reality is that the kind of centralist project includes the kind of co-option of the state by corporations. It includes those things that are happening, that the middle of the left and the right are both complicit in that project.
Yeah, Marbre, I think you're entirely right. And that might actually be the most succinct answer to the question of why so-called social issues are so visible while other issues are so invisible. It's because so-called social issues are the issues upon which you see the clearest distinction between the Democratic and Republican establishment. Issues like abortion or gay rights on the very narrowly construed conception around gay rights to marriage and whatnot. But speaking of abortion, obviously that's always at the center of debate over the courts. But what has this court-centric reproductive rights politics, what does it have to show for itself, given that conservative states have already all but outlawed abortion, and abortion has never been a right guaranteed for many poor women in this country, given the Hyde Amendment that Joe Biden supported until I think maybe just this year? And then a related question on top of that is what you make of Ginsburg's one-time heterodox criticism of Roe as having depoliticized basically kind of, I think her critique is that it sort of created the it fomented the anti-abortion reaction while depoliticizing. Was it that I know that it was that it excited the reaction, but did she also believe it depoliticized abortion rights politics?
So she argued that she thought that you'd probably have stronger support on the ground if you'd allowed state legislatures to sort of continue as they were going. So like New York State, for example, was liberalizing abortion laws, and that in a way what ended up happening by the Supreme Court stepping in is it helped foment counter movement and backlash that over the long run arrested the kinds of rights promotion that was taking place at the state level. Right.
So that's fascinating because her critique seems rather ironic given that it echoes, I think, some of the left's critique of the very sort of liberal judicial SCOTUS veneration that has surrounded her death in particular. So what does everyone make of abortion politics in the court and Ginsburg's one-time critique?
I mean, one thing that I think is striking about the court is how prominent it is, but also how ineffective it can be. So I think whether it is abortion or Brown v. Board, or even we can go all the way back to kind of Jackson and indigenous rights, that over and over again, a decision from the court doesn't actually equal, it doesn't kind of self-create an answer, right? And that I think it also is a moment where we can reflect on the power of people, right? That things happen, that things manifest themselves, that people fight for rights and they're not given. And so whether it's Brown v. Board, I mean, that's right. If you're in Alabama, Roe v. Wade means almost nothing to you, right? There was I think one place you can get an abortion in Alabama after a 48 hour. It's just the obstacles are insurmountable if you're trying to maintain a job and your life. And at the same time, Brown v. Board comes down and we have schools that are more segregated today than they were in the 60s. And so I think the reality is that the court does a lot of kind of performative decisions around social issues. And the irony, I think, may be that when it comes to the corporate stuff we just discussed, it's a much more effective body in terms of those things actually coming to fruition. But I think the reality is that a lot of these other rights are symbolic wins that happen and that capture our attention and our distractions from other issues. But I mean, the efficacy of the court, I think, is an ongoing question when it comes to, and I don't mean to say that as if it's not a huge threat, that when decisions are made that they don't limit or shut down rights, but an opening of rights doesn't manifest itself. And I think it also is a really important reminder that not only are these decisions animated by mass action, but they are also they are executed by mass action. And so it really is the power of people who organize, who both pressure the court to make decisions, as well as then make sure decisions are actually implemented. That is a common through line that's required of, I think, all of these.
Yeah. So I was going to say that I also think, though, that this is an opportunity. I mean, so one of the pushbacks I would have against Ginsburg is that, in a way, what that analysis does is it still fetishizes the states and federalism and local politics. I mean, the simple truth is that the U.S. is a country where you have large majorities that actually support reproductive rights, including the right to abortion. But we have a constitutional system that makes it very, very difficult for mass popular sentiment to actually shape the nature of our fundamental laws. So part of the problem with the court and why there's so much of a focus on it is we basically have the hardest constitution in the world to amend as a formal matter. So you need to get 2/3 in Congress, and then you need to have 3/4 of the states. And that means that all of the conversation about constitutional change ends up going into the arena of the courts. So,
rather than to the question of how to organize constituent power.
Yeah, exactly. So it shouldn't be the case that your right to abortion is dependent on what state you live in. It should be the case that you have mass movements of organized people that are able to impose as a matter of national policy ends that are consistent with what amounts to social justice. And just thinking about Marbre's point with business. So why is it that when the court basically essentially reimposes business rights in ways that really undermine union organizing through some of the recent Supreme Court decisions, or even going all the way back to upholding defenses of things like bans on secondary boycotts and picketing? Why does that have effect? That has effect because corporations are able to assert national power through the point of production. And what's happened instead is we have a constitutional system that allows that corporate power to operate nationally while fracturing people power through an incredibly undemocratic electoral process. So whatever happens at the court, if you win this incredibly important victory. And I still think like Roe's an important victory, but it ends up being Pyrrhic because as a matter of practical electoral strength, it's essentially who has abortion rights remains dependent on whether or not where you live, whether or not you have medical contacts, and what your class status is. Can you travel?
Amna?
I mean, I think once you account for all of the kind of structural dimensions of our formal system of government, there are just so many roadblocks to not just mass politics, but more precisely, I mean, picking up where Aziz was leaving off, to mass opinion kind of translating into legislation or national policy. I don't know. It was one of the things in thinking about this question about how should the left think about the Supreme Court. I think on the one hand, it is absolutely true that the Supreme Court is an undemocratic institution, and we should be imagining ways to diminish its centrality in our political order. And yet, at the same time, it's not like Congress or the state legislatures or the president or our governors are healthy, or that there's like an easy way to kind of influence for, mass politics to influence them. There's such a kind of stranglehold on U.S. politics by organized money and by elites that, there's just so many different hurdles to kind of get through.
I was going to add one other thing about the right's position here. I think it's really important to just highlight how deeply cynical and internally inconsistent the right's critique of the Supreme Court as activist consistent. Because it's not like what the right's arguing is, this Supreme Court is undemocratic, lifetime judges, activist judges. And so, what we should do? We should have national policy through mass referendum that actually represents popular sentiment. Instead, what they want to do is basically take advantage of all of the minority rule dimensions that exist everywhere else in the political system.
The Electoral College, the Senate.
The Electoral College, state legislatures, and gerrymandering. Use all of those pressures to then basically transform the court to maintain permanent minority rule, and then say that the things that the judges are doing, conservative judges, which is like totally activist judging, so, defending the rights of corporations, striking down, the rights of most communities that find themselves oppressed, like maintaining protections for state violence and impunity for state actors, that all of that is just the law, that is just, none of that is activists. That's just like calling quote unquote balls and strikes, to use the baseball metaphor that's always invoked. So, there's a real way in which the right's basically both been able to try to claim the mantle of asserting kind of like they're speaking for the people against this activist court, while systematically imposing a project of sustained minority rule that gets us to the point where we are today.
Yeah, I mean, the right is truly ruthless, something we shouldn't lose sight of in critiquing liberals. But they couldn't be less concerned about the appearance of hypocrisy, because on some level, the level where it counts, it's not really hypocritical. It's a consistent project of reaction, of shoring up social and economic racial hierarchy.
And I mean, it's a project that goes back to the origins of our country, right? Like keeping the we and we the people as small as possible to include we the landowners, we the business owners, we the whites, we the all the things. So I think it's a long project. It certainly is not a new phenomenon. And they have the support of the Constitution and the kind of structure of the country behind them, because that was also the project of our founders, was to keep the we, for the most part, as small as possible.
Yeah, that brings me to a question that I wanted to ask, which is, do conservatives just have a built-in advantage in these liberal versus conservative fights over the courts and the Constitution, given that it's a fundamentally conservative, anti-democratic constitution crafted by framers who conceived of we the people in these incredibly circumscribed terms that excluded Black people, Native people, women, even poor whites?
Aziz, I think you wrote a book about this, so...
My answer is yes, which is why I think that to me, like a big difference between the left critique and the liberal critique is, so, the liberal focus right now is on, okay, maybe we need some court reform because the Republicans have played fast and loose with nomination processes. Maybe the court should be expanded, et cetera. But there's still a real desire to keep the conversation about the court separate from the conversation about the underlying constitutional system. And I think the simple truth is that the Constitution in practice has been a sustained instrument for the preservation of various forms of elite rule. And so one way to put it concretely today is that it is simply the truth that the Republican Party has views that are not majority views. Like the actual set of objectives pursued by the Republican Party does not have majority support. And the solution that the Republican Party has come up with to that problem is essentially to try to take advantage of all of the ways embedded in the constitutional system to sustain power with a minority coalition. And the fact that we can have a situation now where, we'll just think about this concretely. Over the last 50 years, Democrats have nominated 4 justices to the Supreme Court, total Democratic presidents. Trump is about to nominate his 3rd, despite the fact that he did not win the majority vote. 6 of the last 7 presidential elections have been won. The majority vote has been won by Democrats.
And I bet the net Senate vote was for Democrats, but you still get a Republican majority.
We're moving toward a situation where 70% of the population lives in 15 of the states. So you can have long-standing control of the Senate, basically blocking popularly backed, positions. This is even not getting to the questions about gerrymandering and voter suppression, all of that stuff. You can have a majority control in the Senate while essentially having really a very small minority of popular support. These are all things that are embedded in the structure of the Constitution that any system, any popularly organized movement that's an insurgent movement on behalf of democracy has to confront. And that's been there since the very founding. And it was a conscious set of decisions made by the framers. And it's why really any genuinely democratic mass movement has to begin from the perspective of radical constitutional transformation.
Ginsburg's death and the Republican push to install Barrett has suddenly pushed not only court packing, but also D.C. statehood, ending the filibuster, other more dramatic institutional reforms into the center of liberal discourse in a way that I can't remember ever seeing. What do you all make of this dramatic shift on the courts in particular and the anti-democratic state in general? And how should the left relate to it?
I mean, in some sense, it feels like an extension or deepening of the crisis that liberals and Democrats have been facing since Trump's election, to kind of face these long-standing, the history of our country, for example, but also myths that sustain the order in the way that it is. And so I think it's a good sign that we are seeing more debate about how to refashion the court, because the Supreme Court, as kind of the embodiment of law above politics, once that becomes subject to debate about reform, and I still don't really have a sense of how wide-ranging, or how, let's say how many people are actually debating it. I think you're right that in the mainstream media and certainly in the left media kind of sphere, you do see, these kind of different reforms being debated. I don't have a great sense whether or not they're being taken seriously at all by the mainstream Democratic Party, but it all seems good in the sense that it reflects an understanding that the Supreme Court is political, that law is political, and that even the venerated institution that to kind of maintain its hold on the idea that it's apolitical, presumably shouldn't be changed, that even that kind of needs to be rethought. But I think the divide between the liberal reform proposals and the left ones are kind of captured by the traditional divide between a reformist approach versus a non-reformist approach, which is to say that the liberal or reformist approach to thinking about court reform is to think about what do we do to re-legitimate this institution, to reinstall some sense of balance into it, to have a Ginsburg there and a Scalia there so that they can go to India together and then talk about it later and that sort of thing. Whereas the left needs to be and is, I think, thinking about reforms that diminish the Supreme Court's power and therefore diminish elite rule over politics in the country, and to create more space for mass politics. And so Sam Moyn has been writing about this, about reforms that would strip jurisdiction of the court over particular kinds of issues, or to call for supermajorities. So right now, 5 justices have to vote to take a case before the Supreme Court takes a case. That could be changed to 6 or 7 votes. And so what are the kind of reforms that will make it harder for the court to invalidate, for example, the Green New Deal, if that ever gets passed?
Yeah, and I do want to get in the nuts and bolts of these different reform proposals, but I do think, at least on the political discursive level, that even if court packing is not the right court reform, it does seem like an improvement over the mythology surrounding impeachment, that the idea that the Constitution, law enforcement, and the national security state would save liberals. This seems better. Aziz?
Yeah, no, I agree with that, which is, so I totally second what Amna said, and I hope we can get into this, because to me, the big difference between the left and the sort of liberal center-left lane is precisely around what she was referring to as non-reformist reforms. So the left, the reason why you care about these reforms is because you're trying to improvise a new emancipatory social order out of the old. You're trying to create conditions where it's harder for the existing social order to reproduce itself. And that means your primary interest is in expanding the bargaining and political power of oppressed groups, of your own meaningful constituencies, which are not necessarily tied to the Democratic Party or encapsulated by the Democratic Party. But, I will say that one of the things that's interesting about this moment is as the Republican Party basically moves more wholeheartedly toward just, embracing minority rule, so that it realizes it has a quote unquote demographic problem. And the way it's going to address that is by trying to take advantage of anti-democratic institutions to be able to permanently hold on to power even after it can no longer win elections. That's the story of the court. There's a clear partisan alignment of interest with the Democratic Party and projects of democracy. And I think that's where H.R. 1, in a sense, comes from, and even the discussions now about court reform, that it is in the partisan interest of the Democratic Party to figure out ways to actually meaningfully expand and enfranchise people that are being disenfranchised. That doesn't mean, though, that the folks that are within the Democratic Party, again, necessarily have the same overarching objectives as what a left project would be, but it does mean that there's a kind of common cause around a certain set of policies.
I guess I was thinking about this last night. How do you square that with their opposition to the rising left wing within the party? Their opposition to AOC and Ilhan and the Squad, who are mobilizing, I think, more of, they're giving a voice to the mass politics that are locked out of federal, out of congressional debates, or, having a real possibility to become enacted. And they're mobilizing new voters, a more diverse constituency, all of those things. And yet the Democratic Party is fighting them tooth and nail.
So to me, I think part of this is sort of the difference between Democratic Party establishment support for things like ending felony disenfranchisement and the fact that in New York State, or,
not really ending, but lessening.
Yeah, absolutely. So willingness to take positions that the Democratic Party until very recently had just not had on the table remotely at all. And at the same time, what we're seeing in New York State with the effort, for example, by Cuomo and the Democratic Party leadership to crush third parties like the Working Families Party, or the desire of the Democratic Party leadership to protect incumbents and sort of limit the possibility of primary challenges. And in a way, it's a difference between how you conceive of the voter, and then like what are the options that are presented to the voter. So like you can think that, hey, this is a voting base that's going to be voting Democratic. And at the same time, you can think, well, there's lots of other instruments at my disposal to perhaps shape the range of Democratic Party choices that like this particular voter might have, if that makes sense. So I think you can, like I could imagine a particular kind of center-left Democrat sort of thinking about these two moves. Like you need an expanded electorate to defeat Republicans and maintain your permanent power. And then you can take advantage of lots of other instruments and tools to shape the internal terms of what choices are being presented to the Democratic Party's own electorate.
This is Sarah Jaffe, and you are listening to The Dig with Daniel Denvir, my favorite podcast for thoughtful discussions on the U.S. left and beyond. And you can support it on patreon.com.
I want to tell you about a new podcast from Critical Frequency called Generation Green New Deal. If you're terrified of the climate crisis and want to do something about it, this is the podcast for you. Host Sam Eilertson takes a look at how scrappy organizations led by teenagers and 20-somethings have embarrassed politicians, knocked powerful incumbents out of office, and brought the U.S. closer than ever to addressing the issue that will define the future of humanity: climate change. The first season features Varshini Prakash of Sunrise Movement, Naomi Klein, Bill McKibben, Rihanna Gunn Wright, Jamie Margolin, and many more incredible climate activists. Subscribe to Generation Green New Deal wherever you get your podcasts. Let's clarify some of these distinctions between liberal and left proposals to democratize, or in the liberal case, more rebalance the court. Amna brought them up earlier, but we haven't really distinguished them. Court packing obviously is the one that has gotten the most attention amongst liberals, but we've seen people on the left argue that we need to get rid of judicial supremacy in a more fundamental, check judicial supremacy in more fundamental ways by ending judicial review, or as Amna mentioned, requiring like a supermajority on the Supreme Court to strike down a law. Given that it is court packing that's getting so much of the energy behind it at present, is it wise for the left to say, no, we should be doing this other stuff instead? Or rather, should the left be saying yes to court packing, and what we also need are these checks on judicial supremacy?
So I'm kind of where Du Bois and like Norman Thomas, so like basically black radicals and socialists in the 30s were, which is yes plus. So like Norman Thomas, who's a socialist, ultimately backed court packing in the context of the 1930s. But what he said in a letter, which I thought was really well stated, is that he was just surprised by the labor leadership support for court packing, because he's like, how much better is it to be ruled by 15 judges than 9? Like that doesn't actually solve the underlying problem. And so that's essentially my view, which is I'm glad that we're having the conversation about court packing, but I think basically we should think of, there are two ways you can think of court packing, as Amna highlighted. One way is it's a kind of partisan fix that gets us back to some prior moment of legitimacy. And frankly, that's a lot of how FDR thought about the purpose of court packing in the 1930s. He was deeply wary of much more radical and eruptive changes to the constitutional system. It's one of the reasons he didn't actually want a constitutional amendment conversation, because he was worried that like he'd lose control over what happened in the streets. So there's a way in which you can have a court packing story that's about return to normalcy. It's why Pete Buttigieg was the person that backed court reform during the Democratic primary. But you could also have a story where it's like it's the first step in terms of thinking of a fundamental transformation in the court system, really basically like abolishing the courts, the Supreme Court and the federal court structure as we know it. And so that would mean like the things I would support. The U.S.'s Supreme Court is notorious, and that's, I think, the right word, for combining lifetime tenure with no retirement, with an incredibly small number of justices, and no meaningful amendment path. So it just centralizes all of the power in this institution in a way that basically the only kind of equivalent is Ayatollah Khomeini in Iran. Like, I mean, we don't really have other examples of jurists that have this kind of authority. And so, I think what we should be talking about is dramatically expanding the number of justices that are on this court, imposing term limits, having a retirement age, tying it to systematic similar transformations that are taking place in the federal judiciary. There's no ethics requirements on the Supreme Court, and the only ethics requirements for the federal judiciary in general are internal requirements. All of that has to be transformed. We should get rid of judicial review, in my view, as we know it. So have some kind of dialogic function where legislatures can overturn the decisions made by Supreme Court justices. We should tie this to simplifying the amendment process. I mean, so we can imagine a much broader range than just like adding 2 justices or like the truly terrible 5-5-5 plan that Buttigieg presented, which was just a way of entrenching our own partisan divides.
Marbre?
I guess I'm a little more, I was going to just say, I agree with kind of the premise of what you just said, Aziz. I'm a little more skeptical. And Ruth Wilson Gilmore, who I'm a big fan of, often says, we have to assume we will win. And I think the idea of this kind of stepping stone of if we just add more judges now, the next fight will be this like delegitimizing fight. And I think what will happen is we add more judges and that's a hard fight to win and we win it and everyone's like, oh, look, we fixed it. And I think that happens over and over again is that we settle for what are really reformist reforms in the name of stepping towards something transformational and we just never get to step in. So, I mean, I think that for me, at least when I think about what this moment has created for possibility, part of it is desanctifying these institutions. And the reality is the court hasn't always been 9 people. We all know that there's been a long history. And I think that just like kind of capitalism gets mystified as inherent and ahistorical, so does things like the Supreme Court in this moment. This is not a sanctified institution. It's not one that has served us. And then I think what is required is not only the judicial review, and you said this earlier, Aziz, of like literally we have the most difficult constitution to amend unless you are one of these 9 people who gets appointed, who has is not in touch with the actual ramifications of your decisions, but you are anointed to actually change the Constitution kind of in different ways about how you read it. And then I think the supermajority also makes a lot of sense of like, how do we make sure that like the kind of ultimate check before you can, if you can use judicial review, that it is done with the supermajority. But I mean, my goal is to be transparent all around actually rethinking all these institutions fundamentally. And so I think the steps to doing that aren't putting Band-Aids on what are bullet wounds, but instead actually going for the treatment of the bullet wound, which means we might lose, right? So I think there's also like, we have to be cognizant of that. But I don't think having 15 people on the Supreme Court does me as like a Black woman any good in 30 years necessarily, right? Like if there isn't a shift in the ways in which power is operated by that court. And I think that it will allow some liberals and even some like leftists to think that there was a victory when there isn't one. And so I think of like Cabral of claim no easy victories, that doesn't feel like a win. And I think sometimes we think we're on a road to more transformational reform, but in fact, we're giving excuses for folks to stop walking with us. So that was my concern.
I totally agree. Like, I think maybe the thing that I would say is what counts as court packing is really like open right now, so that I think one of the spaces to contest it is basically to say, like, the argument we make is not, the goal is to add just a couple more justices or the 5-5-5 plan that I mentioned earlier. But, within the debate about court reform, to actually make the argument for this like broader transformation, because that is court reform. So it's rather than taking, maybe this is to say, we shouldn't take the terms as given that are presented to us about like what counts as a quote unquote like court packing agenda or a court reform agenda, that like the left or we or, one needs to actually have an articulated plan that fills that space and then contest the policy on those terms.
Amna?
I want to, I think I'm somewhere kind of in the middle, or we're in a little bit of a triangle around this.
I love this triangle. It's very interesting.
So I've been thinking a lot about non-reformist reforms recently, and Marbre and I have been writing an article, which hopefully will come out at some point, about abolitionists and how they think about, or how we think about non-reformist reforms. And so one of the things that if you go back to Andre Gorza's book, Strategy for Labor, so in the socialist context, and then in Marbre and I's article, we talk about this too, the line between reformist and non-reformist reforms is not always that sharp, right? And so I think whether court packing is a reformist or non-reformist reform is probably debatable. And so I think the thing that it has going for it is that it shows the contingency of our political arrangements in our judicial institutions. And it shows I'm not sure about this, Aziz, I'm assuming what is the mechanism for creating more seats? Would it have to go through Congress, or can the president do it, or how does it happen?
Yeah, so there's a constitutional amendment process, but that's of course kind of foreclosed.
Right.
And so there's a legislative process. And the legislative process is that Congress has authority over sort of establishing inferior courts and, in a sense, like creating a legislative scheme for appointment. So you could imagine a legislative package that would provide like new federal judges, and then those federal judges would be able to circle on and off of the Supreme Court. So in keeping with the language of Article 3, you would still have lifetime appointment to the federal courts, but the service of time that you spend on the Supreme Court could actually be limited. So you could serve on the Supreme Court for a shorter period of time, and then you can dramatically expand, for example, the number of judges that go from a lower federal court onto the Supreme Court. You could create a panel system where, let's say, you have, India has 34 Supreme Court judges. Germany has 16. So it's a certain number of judges that are now on the Supreme Court that circle onto it would then sit for particular cases. So it wouldn't be as highly polarized. And you can do all of that by legislation. Of course, there's a big problem, which is all of this would then end up getting litigated in the courts in this particular court. So they would end up making assessments about the constitutionality of these kinds of legislative fixes.
A judicial snake eating its own anti-democratic tail.
Or not yet.
Yeah, so I think, right. So it would require, require political action through Congress at the outset, it seems. And so in that sense, it would require a form of mass politics and mass engagement in order to push the Democrats to even kind of go this far. And so in that sense, I think about kind of what Aziz was saying, but like in a slightly different guise, which is, just like reformists can push defund the police, and what they really mean is like, let's cut the budget by 5, maybe even 15%, and then call it a day. And abolitionists can push defund as a radical strategy to question the very premises of policing and to work towards abolition. I'm not as excited about court packing as I am about defund, but I think court packing, like the stories we tell, the movements that we build around these demands, the people we organize, I think all of those things really matter. And I'm totally with Marbre that this is not the reform that I'm not super excited about court packing, nor is it the reform I would push out of the ones that are being debated right now. But I also agree with Aziz that if this is the one on the table and the one with momentum, I think there's a way to support it in a larger kind of context of denaturalizing the court, raising some fundamental questions about what role it plays in society, and reminding the public in a way that I think movements are doing an extraordinary job of these days, that our political environment, our politics and our political institutions are contingent creatures that we ultimately lend legitimacy, and we have the opportunity to reshape them, to withdraw legitimacy and consent, and to build new things.
Marbre, what do you think about connecting defund to the court project in terms of, do you see a possibility of linking court politics to emancipatory left and black political projects that include both economic justice and ending the carceral state? Because like I said earlier, I find it so bizarre and revealing that we're having these mass movements around criminal justice that are totally separate and not involved in these huge debates and discussions around the high court.
Yeah, I think that's a good question. I mean, I've been thinking about this a lot. A bunch of kind of organizers have been posting about this question of like, is there a Supreme Court in my abolitionist future? And I think it's a really good question. I mean, the answer is clearly not this Supreme Court, right? This is not the version of a Supreme Court that is in any of our abolitionist futures. But I think there's a question that stands about like, what is the role of the state in justice when the state has been so long affiliated with violence against Black and brown and poor people, and still is in every way. And so, I mean, when I think about, one of the reasons why I think that I'm in some ways opposed to the idea of court packing without transformational reform is because I think that the courts, as long as they're seen as legitimate actors, that there's violence that's going to be done to people, right? And so I think whether that is, quite frankly, the calling of prosecution for folks who kill or injure, whether it's, Black and brown folks or anybody, the idea that we want to use the courts as the decision makers or legitimate actors in making sure that justice is done, I think is really problematic. And so I think that's true both on the Supreme Court level, but also on the county court level, and across the board. And so I don't know that there's a relationship, quite frankly, between the court system as it operates now and abolition. What we've seen, I think, whether it's in the last few months, whether it's because of the COVID-19 crisis and now because of some of uprisings, is like a massive expansion of mutual aid outside of the state and outside of courts, right? The people are finding ways to ensure justice, to ensure healing, to deal with harm that have nothing to do with the court system, because for so long, the court system has actually never been about arbitrating justice for Black folks or brown folks in this country. Like, that's never been its objective. It's never been its outcomes. And so I think that there was a kind of a long history of organizing around abolition that's happened outside the courts for very good reason. And it's hard for me to imagine inside of this kind of current configuration that the courts become an arbitrator of fairness or justice in an abolitionist future. And I think that one of the dangers of this moment, and I think, I don't remember, it might have been an article, it was either Ruth Wilson Gilmore or it might have been Keonka Taylor, but writing about kind of the reality that so many of our institutions are really up for grabs, that the COVID crisis, now the uprisings, now the Supreme Court have all kind of laid bare how these failures are multiplying and that these systems aren't actually, they weren't created to serve us. They're not broken. They're doing what they're supposed to be doing. And I think the court system is kind of the best example of that really it's doing exactly what it's supposed to be doing, and has been doing that. And so I don't know the relationship, to be honest, and it's one that I'm thinking deeply about between kind of abolition and defund and the courts. But I do think that the possibility for co-option inside the courts is dangerous and alive.
I think this is a really important point, which is like if after the end of the conversation that we have about the reorganization of the court system, we have a constitutional order writ large in which the courts continue to have this kind of power. And what we think of the Constitution is basically determined by the cases that come up in the Supreme Court. That'll be a massive failure, because a big part of this is like, who are the judges? Like, the judges are actors within the state that are invested. Even the center left judges, where you build like this like cult of the Constitution around, like, Ginsburg, whoever else, that are really invested in the activity of the state and the kind of violence that the state perpetrates. And a central reason why, the abolitionist agenda does not appear before the court is because they get to decide which cases come before them. Then they write opinions. And what gets taught in a constitutional law class at an elite school? The opinions that they write. Essentially, the public has handed over authority over the meaning of the Constitution and the constitutional project to the reform objectives, the vision of a very small set of jurists who are themselves officers of the state engaged in acts of violence. And so, to me, part of this has to be figuring out ways to essentially extract the project of the Constitution and how we think of constitutional politics from the courts themselves, and to dramatically de-emphasize the centrality of the very specific legal elite conversation that takes place on the courts as the primary way that we talk about things like racial reform or economic justice.
I think it's sort of revealing on that count that it's RBG and not Sotomayor who's the justice who's venerated, given that Sotomayor is really the only one on the court who's willing to express skepticism of the carceral state as such.
And is often alone in doing that, which is, I mean, not a shock, but.
Well, here's a related question. Should the left believe in some form of law that is somewhat insulated from politics? Do we want to entirely toss out the liberal notion that the judiciary has a role to play in protecting individual and group rights against the tyranny of the majority? And if so, how would we square that with everything else we've been talking about?
So first, I do think this is something that Amna writes and talks about. So I do think that there's like a defensive role that the law plays for movements in terms of just cases can be a space, litigation can be a way of just limiting some of the extreme forms of violence that exist. So that's like a defensive maneuver that's not really about, radical transformation. So I think that it's important to kind of keep that in mind as something that does occur. And then like for me, I broadly come out of like a critical legal tradition. And my basic view is as a matter of one's politics, that it's essential that you do not keep law and politics separate, that you recognize the extent to which law is deeply infused with power relations that sustain modes of injustice and inequality. But that doesn't mean that as a matter of political practice, I think that we should just collapse law entirely into politics, either domestically or frankly at the international level, because there's this big problem, which is if you engage in that collapse, then oftentimes what happens is that just unleashes the existing forms of power. A lot of the folks that are making arguments about how this is an arena where law doesn't apply are individuals. You can think about Trump in the context of like kidnapping children or the violation of basic like international human rights abroad that are essentially defending their own impunity. And it's the right for a long time that's been making arguments both at home and abroad again that what really should dominate is just like pure politics, or that like actually this isn't a national security arena, might be an arena where law is irrelevant. So I kind of agree with, in a way, what's thought of as like a critical, like a CRT. So the critical race theory position that says that there should be a defense of rights and there should be a way of thinking about law as a tool to hold to account those that claim absolute impunity. At the least, to be able to say that it's a way of holding those in power to the very rules that they themselves have established as just like a bare minimum. But I don't think that that's necessarily, that law is the emancipatory or the transformative tool. And I also don't necessarily think that a rights language has to be litigation driven rather than through legislative or popular means, which historically have been the best way that rights have actually been entrenched.
I'm sorry, Aziz, but President Trump has canceled critical race theory. I regret to inform you. Amna?
Yeah, I mean, it's really hard for me to crunch this question about the role of law in a ideal, kind of idealized left utopia of some sort, because we're so far from that I really, it's hard to know. Because on the one hand, and in thinking and writing and talking to faculty about abolition for the last few years, I mean, one thing that has become clear to me is that for liberals and elites, and maybe even for a lot of the public, the carceral state has such a deep and broad footprint that many of us have a really hard time imagining what the law is without the massive carceral apparatus that is present in the state. So what is the law without mass incarceration and mass policing? Of course, we are unusual in the number of, we're singular in the number of people that we incarcerate in the scale of our police and modes of criminalization. And on the other hand, it's so saturated into our particular notions and experiences of what law and the state are about, that it's hard to kind of separate from that. And on the other hand, of course, corporate power, the workplace, there you have very little kind of regulation of employers. And so, you kind of have what I heard Ruth Wilson Gilmore recently call organized abandonment, right? And so those kind of polls together make it very hard to kind of imagine something different. But I will say this, at this juncture, I think it's essential for the left to embrace law as a form, tool, and terrain of politics. And I think movements are doing that in a way that's really powerful. One of the things that's so important, compelling, striking about today's movement politics is whether or not it's explicitly articulated, today's movement politics are deeply expressing an intuition about the kind of anti-populist, anti-majoritarian nature of the courts, because it's not focused on courts. It's focused largely on local and city politics and on budgets, right? So questions of the purse. And so in that sense, questions of distribution and redistribution, which fundamentally kind of dislodge the centrality of, for example, the rights debates as the central debate for liberals or the left in terms of how to engage with law, are really kind of transforming even what we think of in terms of law reform or reform agendas. So for now, I think that's kind of where I'm at.
Marbre?
Yeah, I would agree with that. It's hard to get into like a left utopian state of mind at the moment. But I will say that I just don't know of any time when the law hasn't been political. And so whether it is like slavery or apartheid or colonialism or kind of genocidal anti-Semitism, like all of these were legal regimes that were organized with laws. And so human rights is also a politic, right? And so I don't know of a kind of an existence of law outside the will of people who are political beings, and society, which is a political endeavor. And so I don't know how to distinguish them. But what I do know, and I think it's important, as Amna said, is that we, as a liberal and a left project, understand that the law is deeply, deeply political in the world we live in right now. And that it's not ahistorical, that it is, and it's not sanctified, that it is both political and therefore must be changed and must be derobed in some basic way. And so, I think that this idea of mitigating harms with the law is important, but also recognizing that, we can't use the master's tools. And so that the law cannot be the only way, the only place that we fight, the only terrain on which we wage battle cannot be a legal terrain. And that, I think, is all important in naming the law as a political entity, because otherwise I think people get caught up and give too much energy and time into trying to fight it inside of courtrooms, when in fact the winning of this battle won't happen in a courtroom, right? The revolution would not happen in a courtroom. And so I think it's important that we recognize that. And like the kind of utopian question, I don't have an answer to, but I do think that it's a necessity that we just know, in my knowledge of history, it's never not been deeply political.
I mean, not to mention, right? I mean, we've been talking for the last 2 hours about the Supreme Court, but the way that most people experience the courts is through their local courthouses that are evicting them from their homes or prosecuting them for crimes, or charging them for some ticket, or something like that, right? And so this is another reason why I think the Left Project is a project in solidarity with working class people, by and for working class people. And because legal process is central to effectuating many of the major forms of exploitation and violence of our times, whether it's eviction, deportation, incarceration, the courts as a site of battle, as a site of kind of creating, we can't disavow that, because they're fundamental sites of violence, inequality, exploitation, extraction, and legitimation of that as having proper process and therefore legitimate. And so, the defensive piece, just to be clear, like that's kind of, I don't know, Aziz, exactly what you were thinking of, but that's what it kind of brought up for me, is that aspect of the courts, which when you focus on the Supreme Court, you don't think about, but is really the real and more kind of practical way that the law shows up in people's lives every day.
It just as like a little additional thought that spurred, which is, this is another thing that's like really destructive about the cult of the Supreme Court justice and of the Supreme Court in particular, because in a way, the focus on the idea that the decisions that get made at the Supreme Court are the product of like this, elaborate reasoning that's grounded in liberal jurisprudence, and it's the height of wisdom. What is the actual practical effect for most people? What it does is it legitimates the entirety of the court system. And what does the entirety of the court system do? As Amna said, like, it imposes daily violence on people. Now, for me, like a version of why this is tough is like I'm a statist, so my politics is a socialist politics, and I actually think that we need a state to be able to implement transformative change. But at the same time, there's no doubt that like the primary way that people end up interacting with the state is in modes that are deeply oppressive. That's like it's another parallel version of the same question about law, which is law is embedded in relations of power that are deeply oppressive. Yet at the same time, like there probably needs to be some arena of law so that folks can be able to, act free of like the impunity of those that have power.
That just brings up a quick thought for me too, of I think that all of these courts, whether it's like, the court that is literally stealing money out of your pocket for fees and fines, or the court that puts you in a cage, or the court that, all of them, limit and vet who can act inside of them in a way that I think is really, really limiting of mass movement. And so you have to have a law degree, you have to, like, there's all these levels of elitism you have to reach to actually be a speaker inside of these systems, which I think is just a recreation of kind of the ways in which all of these systems are trying to limit popular democracy and kind of popular engagement in different ways. And there are some amazing projects, the Participatory Defense Project, which is like trying to open up these spaces to be more democratic than they currently are. But I think that this elitism reproduces itself from the Supreme Court that it's just 9 people all the way down to, the fact that you have to have a lawyer in criminal court, and that that there's no way to operate without a law degree effectively for your own benefit. So I think that there's a reproduction of elitism that's dangerous.
And that's being carried to an even more extreme conclusion by the conservative legal project of restricting further and further and further who has standing in any given case.
Absolutely.
To an extent where
absolutely.
With this emoluments case, are arguments being made essentially that no one has standing. which is wild.
I mean, I think I said this before, but I'll just say as my closing argument that the Supreme Court has never protected us and won't ever in this form. And even if we pack the court, we make the court, the reality is that we are the ones who protect ourselves, that it is mass movements, it is organizing, it is folks who don't have law degrees very often or not legal experts who actually enact change. And so I think naming that these are really relevant fights, but actually the fight that's happening in the streets, that's been happening all summer, all decade, all century, is the fight that I think it's worth paying attention to and feeding. And that is the fight that actually dictates these other decisions.
Yes. So like just like kind of connected to that, I mean, the thing that's really key for me is that the U.S. is not now and has never been democratic. And the legitimacy of the Supreme Court rests on the idea that there's some set of like ideal economic and political and legal arrangements that just basically need effectively to be preserved by an insulated body. And all of that is a deeply destructive fiction. And so it means that if the country is not now and has never been democratic, then the project of the moment is to truly transform the society in keeping with genuinely emancipatory ends. And that means taking the Constitution effectively away from the courts, having straight, like real discussions about what a transformation of the constitutional system as a whole would mean, and like focusing on the kind of mass mobilization and insurgent democratic politics that would be necessary to get us there.
Perhaps on a more pessimistic note, this is the thought that I'm left with after thinking about all of this, is that, of course, one of the things about neoliberalism is that it's intimately tied with, or an aspect of it is the rise of the carceral state. And so because of that, the main way that the state shows up in people's lives is through prisons and police. And so one of the things I'm left with in thinking about how evictions, deportations, traffic court, criminal courts, prosecution, and policing are the main way that the legal system is in people's lives is precisely that the courts are kind of the daily infrastructure and footprint of the courts is deeply intertwined with the shape of the state in people's lives. It's not just about policing and prisons. It's also about having to go to court. And so that just kind of underlines the point that Marbre was making about being very careful in how we engage with the Supreme Court to make sure that our project is never to legitimate that institution, because it always re-legitimates the kind of the footprint of the court system across the country in the way that Aziz was describing. And so when we think about what kind of like arguments or reforms, the line between a reformist and non-reformist reform, holding in mind the actual presence of the judicial system and what it looks like, and the relationship between that and the Supreme Court seems very central.
Well, Aziz, Rana, Amna, Akbar, and Marbre Stahly-Butts, thank you very much.
Thank you.
Thank you.
That's great.
Thank you.
Thank you for listening to The Dig from Jacobin Magazine. As Marx once said, after noting that the police, the judiciary, and the administration are not the representatives of civil society. They are the representatives of the state, and their task is to administer the state against civil society. While other podcasts have only interpreted the world in various ways, our point is to change it. We are posting new episodes every week. The Dig was produced by Alex Lewis, music by Jeffrey Brodsky, and a belated congrats to Jeff on his new-ish baby. Our communications coordinators are Julia Rock and Zachary Nin. Our senior advisor is Thea Riofrancos. Check out our vast archives at thedigradio.com. We've got every single episode organized by topic and author. Check it out. Follow us on Twitter at The Dig Radio. Please find us wherever you get your podcasts and subscribe. If it is on iTunes, you can also please leave us a glowing review, rating, etc. Those reviews help introduce us to new listeners. But what really and truly does that is you telling your friends about the show, why you listen, why they should listen, etc. Please make propaganda for us. And do find us at patreon.com and make a monthly contribution to keep this operation going. Even a few bucks is huge.